This is a brief discussion on the nature and effects of preterition under Article 854 of the New Civil Code and how it is distinguished from disinheritance. Article 854. The preterition or omission of one, some, or all of the compulsory heirs in the direct line, whether living at the time of the execution of the will or born after the death of the testator, shall annul the institution of heir, but the devices and legacies shall be valid insofar as they are not in officious. If the omitted compulsory heirs should die before the testator, the institution shall be effectual without prejudice to the right of representation. As explained by Honorable Justice Eduardo P. Caguioa, preterition consists in the omission in the testator's will of a compulsory heir in the direct line or any one of them, either because they are not mentioned therein, or although mentioned, they are neither instituted as heir nor expressly disinherited. The act of totally depriving a compulsory heir of his legitim can take place either expressly or tacitly. The express deprivation of the legitim constitutes disinheritance, and the tacit deprivation of the same is called preterition. In order that there be preterition, it is essential that the heir must be totally omitted. Summarizing, therefore, total omission means that the omitted compulsory heir receives nothing under the will, whether as heir, legatee, or devisee, has received nothing by way of donation inter vivos or propter nuptias, and will receive nothing by way of intestate succession. Meanwhile, Honorable Associate Justice Arturo de Drion explains the nature of preterition in the case of Morales versus Olondris thus: preterition consists in the omission of a compulsory heir from the will, either because he is not named, or, although he is named as a father, son, etc., he is neither instituted as an heir nor assigned any part of the estate without expressly being disinherited, tacitly depriving the heir of his legitim. Preterition requires that the omission is total, meaning the heir did not also receive any legacies, devices, or advances on his legitim. In other words, preterition is the complete and total omission of a compulsory heir from the testator's inheritance without the heir's express disinheritance. Based on the foregoing discussion, the requisites of preterition are: 1. There is a total omission in the inheritance. 2. The person omitted is a compulsory heir in the direct line. 3. The omitted compulsory heir must survive the testator, or in case the compulsory heir predeceased the testator, there is a right of representation. And 4. Nothing must have been received by the heir by gratuitous title. Also, based on the foregoing discussion, the effects of preterition are: 1. Preterition annuls the institution of heirs. 2. Devices and legacies are valid insofar as they are not in officious. And 3. If the omitted compulsory heir dies before the testator, the institution shall be effectual without prejudice to the right of representation. Rights of the Prateritan Air. Under the Civil Code, the preterition of a compulsory heir in the direct line shall annul the institution of heirs, but the devices and legacies shall remain valid insofar as the legitims are not impaired. Consequently, if a will does not institute any devices or legacies, the preterition of a compulsory heir in the direct line will result in total intestacy. Preterition will result in the annulment of the institution of heirs in the will, hence legal or intestate succession will apply. This is in consonance with Article 960, Paragraph 1 of the New Civil Code of the Philippines, which states that, open quote, legal or intestate succession takes place: 1. If a person dies without a will or with a void will, or one which has subsequently lost its validity, close quote. The preteritan heir, therefore, is entitled to receive his or her legitim as a compulsory heir, and to the free portion not expressly disposed of by the testator by way of devices and legacies. The proper legal remedy of the preteritan heir is to oppose the probate of the will if the other heirs would like to give effect to its provisions. Preterition versus disinheritance. The Supreme Court, through former Associate Justice Amior Fina Melencio Herrera, explained the distinction between preterition and disinheritance in the case of Rafael Maninang and Soledad Maninang versus Court of Appeals et al. Thus, preterition consists in the omission in the testator's will of the forced heirs or any one of them, either because they are not mentioned therein, or though mentioned, they are neither instituted as heirs nor are expressly disinherited. Disinheritance, in turn, is a testamentary disposition depriving any compulsory heirs of his share in the legitime for a cause authorized by law. Another distinction between preterition and disinheritance is, disinheritance is always voluntary, preterition, upon the other hand, is presumed to be involuntary. The effects of preterition and disinheritance are also totally different. Preterition, under Article 854 of the New Civil Code, shall annul the institution of heir. This annulment is in toto, unless in the will there are, in addition, testamentary dispositions in the form of devises or legacies. In ineffective disinheritance under Article 918 of the same code, such disinheritance shall also annul the institution of heirs, but only insofar as it may prejudice the person disinherited, which last phrase was omitted in the case of preterition. Better stated yet, in disinheritance, the nullity is limited to that portion of the estate of which the disinherited heirs have been illegally deprived. This is the end of this presentation. Thank you.